The remainder of this video will talk about legal, the concept of legal in nursing, as well as professionalism. So before we start talking about legal, let's talk about what a law is. So laws are established to protect society, and nursing practice is guided by legal principles. So the purpose of a law is to protect clients and society. You may have laws such as the Nurse Practice Act that defines the scope of practice for nurses, as well as the minimum level of care that should be provided. So a law enforces a minimum level of conduct, and it's enforced if someone has imposed, it's enforced by imposing penalties for not complying to that law. So some of the professional standards that nurses have in response or in connection to legal and nursing are our Nurse Practice Act. So the Nurse Practice Act defines the practice for a nurse. It is a statutory or state law and basically lists violations that could result in disciplinary action for the nurse if they were to violate those laws. So each state has their own Nurse Practice Act. The Nurse Practice Act is there to protect our patients. It also identifies the minimum level of nursing care that should be provided. It's important to know that it defines your practice limits. So it tells us not only what we should do and what that minimum level of care should be, but also where our care is limited. What would go outside of our scope of practice is identified in the Nurse Practice Act. So it's important for you as a student nurse to know that when you're practicing at the hospital, you are practicing under your own, you do not have a license yet, but you're practicing on your own volition. So as a nursing student, when you are practicing, if you were to make an error and patient harm would result from that, then you are not practicing under anything at the hospital. You're not practicing under your nursing instructor's license. You're practicing in your own volition. So if something were to happen, then absolutely you would be responsible as a student nurse. You are held to the same standard as a practicing nurse. So for an example, if a nurse sees radiology results on a patient, and based on her previous practice or his previous practice, they determine that the patient has pneumonia. So if the client asks the nurse about that chest x-ray or radiology result that was done, and the nurse tells the client that they have pneumonia, this is a violation of the nurse's practice. So the Practice Act says that on 7E, which is one of the statements on the Nurse Practice Act, that collaborating with other healthcare professionals to determine appropriate healthcare for a patient is subject to a certain provision within the Nurse Practice Act, but basically not prescribing medical treatment. Nurses aren't to make medical diagnosis except under the supervision of a licensed physician or healthcare provider. So that's part of the Nurse Practice Act. That's one of the reasons why we can't tell patients what their results are, is because that is out of our scope of practice. Another standard that we use in terms of our professional practice would be the ANA standards of practice. And so the American Nurses Association defines those activities that are specific to nursing. In box 1-4 in your fundamentals textbook, it's going to detail things like assessment, diagnosis, planning, outcomes, coordination of care, how to evaluate, ethics, and education. So all of those 5 steps of the nursing process being the first 5, and then coordination of care, ethics, and education are all considered a part of the ANA standards of practice. And then your institutional policies and procedures, those are what you are responsible for knowing where, whenever you work and whenever you practice, that you follow your institutional policies and procedures. So the way that goes is your Nurse Practice Act defines what you're able to do within your state. The ANA standards of practice is going to be for all nurses practicing in the United States, and those institutional policies and procedures are specific to the facility that you're working under. So that's why there's 3 different things for you to know about professional standards. So let's talk about HIPAA. I know that you're well rehearsed in that. You would have taken core orientation, even if you've never worked in a healthcare setting. When you first started the program, you had to go through core orientation and learn all about HIPAA. So HIPAA stands for Healthcare Insurance Portability and Accountability Act. Its job is to ensure that patients have the right to view their health record, to update the record, to ask for corrections of mistakes if there were a mistake made in their health record, and also to request restrictions on how the facility discloses information. So it's not just a privacy law. It was developed to protect insurance benefits for workers who lose or change jobs and help protect people who have pre-existing medical conditions. So only a person in a protected relationship can access patient information. You can't be forced to reveal communication unless the patient agrees to it. Some of the things to keep in mind with HIPAA that we don't think about, a lot of times we talk to you guys about maybe leaving a computer open in the hallway or being logged into a medication dispensing system, and all those are definitely HIPAA violations and could result in action against the nurse, in action against the facility, and could have huge ramifications for us also in the nursing program if there was a breach of patient information. But some things that you may not think about, but that might affect you later when you're practicing would be stolen laptops. Let's say you have your laptop and you have, if you had taken, which I hope you never do, taken a picture of your patient's labs and that was saved on your laptop. If your laptop was ever stolen, then that information would be considered a HIPAA violation if that was discovered. Texting client information is a HIPAA violation. Texting or posting to social media about a patient is definitely a violation of HIPAA. Social breaches such as general conversation about a patient, and one of the examples that I showed you in communication was when the 2 nurses were talking about the mayor being in the hospital, or even illegally accessing files. So let's talk a little bit more about social media. So just an example for you is several years ago, I believe it was in North Carolina, there were many nurses in an emergency department who were fired. And so what had happened is there was a patient who came to the ED. The patient had presented with something inserted in their rectum. I cannot remember now what it was, but I believe that it was an animal of some sort. That patient had to have an x-ray to determine how far up the rectum the item was so that it could be retrieved. So the nurses found this funny, as nurses can do, because we have this horrible sense of humor because we are exposed to so many terrible things all the time. We try to make light of situations. So these nurses had taken a picture of the x-ray. They posted this to social media. No patient name was used. But it got back to the patient. Even if no patient name is used in the posting of anything, if it can be traced back and they can figure out based on timing, based on information that would be protected information, then that is a HIPAA violation. And so I think it was 3 nurses from this particular ED department had either commented on or uploaded this image, and they were terminated from their job. So it's a really serious violation when you talk about violation of HIPAA. Let's talk a little bit about illegally accessing files. So when you're at the hospital, there's certain things that are in code into the hospital computer system. So if you were to, let's say, okay, my name's Jenny Little. I have a cousin named Mark Little. I'm just making this up. And I want to access, let's say he just had a COVID test. I want to see if his COVID test is positive. He asked me, could I check that for him? Even though he's given me permission to do that, I do not have any connection to him. I do not have a duty to take care of him. I'm just there as a clinical instructor, and I go and look up his test results. So that's a HIPAA violation. So what happens is, because my last name is Little, they may have a tag in their computer system. So if I look up any patient with that name, it may send a flag to the IT department that I may be potentially accessing files. Now, I may be taking care of somebody named Mr. Little on the floor, and if I'm supposed to be in that chart, then absolutely that's not illegally accessing files. But even if you access your own files, you are using that data system in violation of the policies of the hospital. So you should not even look up your own patient information when you're on site. Let's talk a little bit about informed consent. Now, I realize that what you have here on your PowerPoint slide, you probably can see pretty decent on the presentation that we're looking at, but I'll also upload, excuse me, the image so that you can have it for study, because I think it's always helpful to have acronyms if at all possible. So let's talk a little bit about informed consent. So informed consent's really not been around for a real long time, so I'll give you a little bit of background about informed consent. So back in 1914 was the first time that informed consent even came up. Up until that time, you just told your doctor what you needed done, and he did what he saw fit, or she did what they saw fit, and you had whatever they needed you to have. You didn't have to sign a consent form, you just went in and did it. So back in 1914, there was a physician who removed a tumor from the abdomen of a patient. The patient had only told the doctor that they just want to figure out what was going on, but the doctor was in there, figured out what was going on, and said, you know what, there's a tumor here, I'm going to go ahead and take it off. So the judge in this case ruled that the physician was liable for battery because he violated the individual's fundamental right to decide what was being done with his organs, or for his organs, or his body. So the first case actually defined the elements of, meaning what we had to obtain when we get informed consent. It didn't even happen until the late 1950s. So basically what happened in 1914 is they determined that the doctor can't just do what they want to do. They do have to ask permission first. And then in 1950, there actually laid out some laws regarding what you are to do when you're obtaining informed consent. So that was just a little history lesson. Don't expect you to know that for testing purposes or anything like that. I just think it's interesting to know kind of how things come about. So informed consent is not required if this is an emergency situation, if there's an immediate threat to life, then you don't have to have an informed consent, because if taking the time to get the informed consent can cause the patient more damage than actually just going forward and doing the procedure, then absolutely that is an implied consent. It is needed for admission and to a hospital, to a healthcare facility, for any diagnostic procedures and surgery. So in North Carolina, to provide informed consent, you must be over 18. The healthcare provider, not a delegated representative such as a nurse, should discuss all of these elements. They should discuss the diagnosis if they know it, the nature and the purpose of the treatment or the procedure, the risk and the benefits for the treatment or procedure, the alternatives regardless of the cost, the risk and the benefits of those alternatives, and then the risk of and the benefits of not receiving the treatment at all. The informed consent has to be written. It has to be signed by the person who is legally responsible for the patient. If the client does not speak English, an interpreter should be provided, and the consent should be provided in the language that the client speaks. Excuse me. If the client doesn't read or write, the consent should be read out loud to the patient, And you should document that this was done. So there should be a narrative note to indicate that the patient is unable to read and that the consent was read verbally. If the patient can't sign their name, they can mark an X in lieu of a signature. So I told you everything that the healthcare provider needs to do. So let me tell you what the nurse needs to do. So the role of the nurse in informed consent is simply to confirm that the signed consent is there and answer any questions that the patient may have about the consent. So the nurse may have to have the client sign the consent form, and the nurse would then sign as a witness, but only after the healthcare provider has explained the procedure to the patient. When the nurse is documenting, they should always make sure that the patient understands what they're signed, have the patient describe in their own words what they understand, and if the client refuses to sign a consent, that should be documented that the client was informed of any consequences of the refusal. And if you feel like the client needs further information, then you need to provide that, or you need to communicate that to the healthcare provider. It is the healthcare provider's responsibility to make sure that the patient is educated about the informed consent. So we'll have an example that we'll do when we have our live session that hopefully will help you understand your role in informed consent. Now we'll talk a little bit about mandatory reporting laws. So mandatory reporting laws require nurses to report communicable diseases. We learned that more than anything this year when we're talking about COVID. So definitely anything that is communicable that can be passed to our community is something that you would report. COVID exposure, flu, TB, malaria. Also, abuse falls into mandatory reporting. Any suspect of physical or sexual or even emotional abuse, neglect of children, neglect of older adults, those things would definitely need to be provided, and they are mandatory that you report, which means you don't have a choice. So to protect you when you report, these mandatory reporting laws protect you when you report. The identity of the person who calls in to report is kept confidential. However, if you fail to report, you could be charged with a criminal misdemeanor. So it's important that you follow through and you always report any suspect of communicable disease or abuse. The duty to report takes priority over privacy, so you can't be charged with a HIPAA violation if you report, but you can be liable if you do not report. So you do have a duty to report. Nurses have a duty to report any action or any finding that can result in harm for a client. And then the last big one that we'll talk about before we move on to a little easier one is patient rights. So patients have the right to have advance directives, living wills, etc. And we're going to go over some of the differences between those different forms. So an advance directive instructs caregivers as to what the client's wishes are about treatments. It provides an ongoing voice for the client if the client is unable to or has lost the capacity to communicate their decisions. A living will is a legal document. It is a type of advance directive, and it is usually communicated that a competent adult makes their wishes known of their healthcare choices. It usually, a living will provides specific instructions about what should be provided or what should be withheld to the patient. There's usually authorization of the healthcare provider to either withhold or discontinue life-sustaining procedures, and it usually details under what conditions the patient would like that to be completed. A durable power of attorney actually appoints an agent that the patient has established a trust with, and that agent will make decisions in the event that the patient is incapacitated. A POST is another type of form. This is a physician order for life-sustaining treatment. This is actually a medical order. It's not, it's really not defined as a legal document per se, but it does have some legal standing. So it is a medical order, and it's indicated what the client's wishes are regarding treatment. It provides that medical order for current treatment, and the healthcare provider actually consults with the patient to ensure that their goals are represented. You may see this abbreviation changed in some states to a MOLST, M-O-L-S-T, or a MOST, M-O-S-T, which is a medical ordered scope of treatment form. So you may see different abbreviations in different states, but we use a POST in North Carolina most of the time. You also have a DNR, and I'm sorry I skipped around on that. A DNR means no attempts would be made to resuscitate a patient whose breathing had stopped. The nurse has an absolute duty to honor a DNR, and failure to do so could result in battery charges against the nurse or negligent infliction of pain and suffering. The patient themselves can revoke a DNR at any time, or a living will, and allow natural death. Verbiage is a new term. So you may see the term and, A&D, and in place of a DNR, that A&D stands for allow natural death. That's just a change in verbiage that you may see coming down later. I haven't seen it in practice at all yet. But it's new, and it's just a change in verbiage. It just sounds a little bit better to say allow natural death versus do not resuscitate. It typically makes families feel a little more at ease about that choice. Another one that you may see is a DNI, which is a do not intubate. So that patient may I'll still allow the healthcare provider to administer life-saving medicines, but not necessarily not allow for intubation. So now let's talk a little bit about an AMA, or leaving against medical advice. So sometimes patients decide to leave the hospital or other care settings before they're ready to be discharged, and that is considered leaving against medical advice. So for AMA, the patient's legally free to do this. That's their choice. It does carry some risk for increased illness, a longer duration of illness, or for the patient to possibly have complications. But a patient who leaves AMA, there is a certain procedure that nurses need to follow when that patient requests to leave. So if that were to happen, most hospitals have a form that the patient should sign that releases the healthcare provider and the healthcare institution from any legal responsibility if there's a change in the patient's healthcare status after they leave the hospital. That the patient is informed of any possible risk before they sign the form, and then the patient's signature must be witnessed, and then the form becomes part of that patient's medical record. The patient is also informed oftentimes that if they leave AMA, it is not uncommon for insurance companies not to pay for their entire hospitalization. A lot of times that's just simply enough for the patient to decide that they don't want to leave AMA. But again, we don't restrain them and hold them if they don't want to stay in the hospital. So that AMA form is completed, and that documentation of any risk have been discussed is going to be documented in a narrative note. However, oftentimes when a patient wants to leave AMA, they're not always very agreeable to sign yet one more form before they leave. So if that happens, if your patient either leaves the hospital and you just walk in the room and they're gone, or they want to leave and you come in there with a form and they're like, nope, not signing it, then what you need to do is simply document that patient's refusal to sign the AMA form. And you would document that in a narrative note. And it would be specific to what that patient said. Either the patient was not in their room when you went to have them sign, or they simply refused, and used quotations as much as humanly possible when that AMA refusal to sign needs to be documented. So the next thing we'll talk a little bit about is professionalism and professional identity. So professional identity simply means knowing your scope of practice, knowing your personal, your state's Nurse Practice Act, and then that your personal identity is separate from your professional identity. Basically, the way you see yourself as a nurse, the way you behave when you're clocking in on the unit, from the time that you're there on that unit until the time that you clock out, you should exhibit professional behavior. And then when you clock out, you can be you, your home self. So you do not have to be professional at home, but when you are on the clock and you are representing nursing, then you definitely need to be professional. So I'll talk to you about an example here in just a second. So there's a few things I'll talk to you about red flags and signs of inappropriate behavior. Be really careful. We spend a lot of time with our patients and we talk to our patients, and sometimes our patients divulge very, very intimate details of their lives. We can listen to that because maybe the patient needs to tell us these things. Maybe it's important to their health care. Maybe they just want to talk to us. That's okay. But be very careful you professionally drawing that line when you are speaking with the patient about personal issues or intimate issues. Your patient is not there to be your counselor. Your patient needs you to help them. So be very careful and do not divulge intimate details of your life to that patient. Now, it is okay to have dialogue with them and certain things can be said, but you do have to be professional about it. Don't divulge too much information and don't use your patient as your personal counselor. You would not want to, you would be very careful in flirtatious behavior with patients that could be interpreted, anything that even could be considered or interpreted as flirting. You would want to be very careful with that. Keeping secrets with a patient or for a patient. Spending more time with one patient, with just a specific patient than you do with others. Even talking about your colleagues or your employment setting with a patient, that's all unprofessional. Showing favoritism to certain patients. Meeting a patient in a setting that is not your direct work setting can also demonstrate problems with over-involvement of the nurse. So just a couple examples of that. Years ago, actually, I believe it was the first year that I was ever a nursing instructor, I had a student come up to me telling me what a wonderful day she had, what a great patient she had had. And she's so excited because the patient lived near her, and she gave her telephone number because the patient lived alone and she was worried about going home. And she told her anytime she wanted to give her a call, she would be happy to answer any questions she had about her health care. So that is inappropriate, and it may be what that student at the time felt like it was helpful and something that maybe the patient needed. She was worried about the patient not having the care they needed when they got home, but it was also outside of her scope of practice. Number one, she wasn't a licensed professional yet because she's still a student. Number two, she gave that patient personal information. Your telephone number is definitely an intimate detail of your life that you do not share with a client. Plus, if there ever was an encounter outside of the hospital setting, then that's just yet another breach of professional behavior. So just be very careful with that for professional behavior. And if you have any questions, we'll certainly talk about it when we have our live session. So if you notice that you have a possible boundary violation or you think that there could be some misconduct, you definitely need to be prepared to deal with any violations that you may note as part of the healthcare team. If a healthcare provider's behavior indicates that you're really not sure whether or not there could be a violation, you definitely want to use your chain of command, consult with a trusted supervisor about that, and make sure that instances are reported and documented in a timely manner through your hospital's policy, how they would deal with that. And then make sure that you comply with your legal and ethical mandates. So making sure that you're following your Nurse Practice Act and then following ethical standards, making sure there's no harm done to a patient, no violations of the ethical code of conduct within your state's practice.